Sorry about that. Yes, Your Honor. Good morning.
Good morning. All right. Mr. Parnell, I didn't see a response. Did you file anything?
I filed one on Monday and it got rejected, Your Honor.
Yeah, because it was late.
Was it? Okay.
That's why I assume it would have been rejected, but again. Ooh. Go ahead. Here, let me call the case. Calling case number 24-005981, Daniel Vanderlei versus Richard Estes. Appearances, please.
Good morning, Your Honor. Daniel Vanderlei and pro se, plaintiff.
David Parnell here on behalf of the defendant, Your Honor.
Okay, go ahead, Mr. Vanderlei.
Good morning, Your Honor. Today is a motion for summary disposition under MCR 216C10. On introduction, on August 18, 2022, I purchased a property on Bayless Street that had 3 units via Wayne County Mortgage Foreclosure Auction. Since that date, I have been the title owner of the property. Attached is Exhibit G, order from Judge Paolucci saying as much. The next day, I found out that one of the tenants was not a tenant, but was a squatter who was taking up 2 floors. Regarding the squatter, his name is DeAndre Brown. He found the property through a friend, Brianna Leverett, who lived 2 houses south of the property I purchased. On March 28, 2022, DeAndre signed a lease and received keys to the property from defendant Richard Estes. I have that Exhibit A, B, E, and K. Further, squatter gave money to Richard Estes for the rental of the property. In April 22, DeAndre learned that Richard Estes was not the owner of the property, and DeAndre was a victim of a rental scam, at which point he discontinued payment. That's in Exhibit A, E, and K. Eva Royal and her family came over in June of 2022 and attempted to physically remove the squatter from the property. Brianna, his friend, called the police. The police stopped the attempted eviction because of the lease document in the file. In November 2022, the estate filed to evict DeAndre and defendant Richard Estes in 36th District Court. Both DeAndre and Richard Estes were evicted by 36th District. That's Exhibit H. So the evidences that I present, the court is presented with a signed affidavit in Exhibit A from James Nuker, now deceased, stating that there was a lease between himself, defendant, and DeAndre Brown for the rental of 1621 Bayless Street and the 1-bedroom renovated attic. Exhibit C is a cease and desist that I issued to Richard Estes on September 5th, 2022, instructing defendant to remove the squatter from the property. Exhibit D are responses from defendant to myself via text message, stating that he thought that he would have been the owner of the property, but also acknowledging receipt of the cease and desist. Exhibit E is a signed copy of the lease provided by DeAndre through Brianna Leverett. It has been verified in the deposition with DeAndre Brown. I have a video and a transcript of that attached. The court is provided with the deposition, of course, of DeAndre Brown regarding that lease signing. That's Exhibit E. The court is presented with the order of eviction. That's Exhibit H. And the court admissions from a prior case that the estate says, look, we did not give anyone permission to rent to this DeAndre Brown. DeAndre Brown is a squatter. That's in Exhibit I. So there's agreement on the evidence. The defendant has acknowledged a signed lease. That's Exhibit J, paragraph 12. I wrote in the claim, quote, the lease was executed by Richard Estes, where he defines himself as landlord. Defendant Richard Estes answered, quote, admitted that a document called lease was signed by Richard Estes. Also in Exhibit J, paragraph 27, I wrote, quote, approximately 5 months after the former owner died, the property was being controlled by the probate estate. The defendant decided to rent 16621 Bayless. And the defendant entered, quote, admitted, end quote. So the admissions match perfectly with both DeAndre Brown's deposition and with James Nuker's affidavit. I don't have to go over the case law for you. Adams v. Cleveland v. Cliff Iron Company lays out the elements. Simply, if there is trespass or intrusion upon the land, then damages, nominal damages are presumed. And if there's actual damages caused by that trespass, they can be awarded. Posner and Keaton goes on further to talk specifically about people entering the property. It quotes, the trespass may be committed not only by entry upon the land, but by casting objects upon it, or by causing a third person to enter. The defendant may be carried onto the land by force, pursued to enter through fear, or led him to enter by false representations or by grant of the land or inducement, which is exactly the case here. There's a fraudulent lease, and defendant handed keys to the property to the squatter. The Wiggins v. City of Burton 2010 Mish app also specifies it is well-established principle of law that all persons who instigate, command, encourage, advise, ratify, or condone the commission of a trespass are co-trespassers and are jointly and severally liable as joint tortfeasors. So regarding the violation of the trespassed lands by Richard Estes, DeAndre Brown is a squatter. He gained access to 16621 Bayless by fraudulent lease. That lease was written, signed, and executed by Richard Estes. DeAndre Brown maintained the occupancy of that property for 322 days until he was given an order by 36th District Court of eviction. He left the property of his own will before the bailiff could move him out. There was already a bailiff ordered and scheduled for eviction. By order of Judge Paolucci, I've been the fee simple owner of the property since the day I bought it, August 18th. And the more additional evidence is there, non-dispute, right? So C10 is all about what we've already agreed to and why we can rule without having to go to trial. So both parties have agreed that there was a contract for lease between defendant and DeAndre Brown. Defense expresses that in Exhibit J, paragraph 12 and 27, and I, the plaintiff, express that in Exhibit A, B, and E.
So you received a copy of the, I just looked in the system. I didn't see it. It's defendant's response in the system.
No, this is all in my exhibits. The defense does not have a response. These are exhibits, but those were answers that they've already provided, and admissions that they've already provided. So these are the two admissions in Exhibit J that they've already provided answers to. So defense does not dispute and provides no evidence to contradict that DeAndre took up residence in 16621. We have a long history, including the evictions, showing that he did. Defense does not dispute and provides no evidence to contradict the plaintiff was the title holder, which I have Judge Paolucci's order. Both parties have agreed that the Section 8 price of 2022 was a fair rate to charge for the 2 units occupied by DeAndre. So now all I have is calculation of damages. It's in the brief, $6,800 for water, $20,450.22 for rents that could have been achieved. So the total is $27,250.95. So thank you for your time.
Okay, go ahead, Mr. Parnell.
Your Honor, this is, I think, the third or fourth time up this case has been before either this court or the probate court or 36th District. My client is a close family friend to Rubinette Dampierre, who is the deceased. Mm-hmm. Quite frankly, he was helping her pay bills at this house, but he has no evidence or any sort of anything that ties my client to this. My client never collected any rent. The plaintiff purchased this as is. So quite frankly, as I've explained to plaintiff, we don't really have any knowledge of this. We never collected rent. We never exchanged keys. There's another party involved here, James Nuker, who's deceased. So we're kind of operating on little to no information here. There's some damages of the property that I would almost just say that this is for probate court. And quite frankly, there's so many factual disputes in this case that I had trouble even responding to this. I responded with affidavits, which is all I could really do, but there's another party, which is Eva Royal, who was apparently the estate representative for Rubinette Dampierre as well. And I wish we had more information that we could give, but we're kind of out in the lurch on here.
Yeah, well, I looked in the system. I don't see anything having been filed. You have to come to the court with evidence, and I didn't see any. I'm not sure what I can do at this point, when you don't have any evidence to dispute anything that plaintiff has said.
Could we ask for an adjournment so the court can review my response?
But your response isn't in the system. That's the problem. Do you know why it was rejected?
Let me see. I'll tell you exactly what they said.
I would rather decide this case based on the proofs rather than a technicality. Here, I've given you guys an opportunity.
It said it was a late filing, Your Honor.
That's why, because you didn't get it in time.
That's correct.
No. Counsel, why didn't you get it in time? Why didn't you have it?
I believed
last Friday?
I'm sorry. I believe that I filed it appropriately. I didn't have a, and I'm looking right now through my file. I didn't have a summary disposition scheduling order.
Because it's dictated by the court rules. They say when responses are due.
Okay.
All right, counsel, here's what I'm going to do. I'm going to adjourn this. We're not going to have further oral argument on this. I'm going to give you an opportunity to respond, see if there is any evidence and dispute so that the court can make a decision. If there's not, I'm going to grant dispositive relief in favor of plaintiff, but today's the 2nd. I'm going to adjourn this without oral argument to the 16th. Refile your response, and then plaintiff has an opportunity to file a reply brief, and we'll go from there.
Thank you, Your Honor. I'll file it today.
Thank you, Your Honor.
Thank you. All right.